It seems odd that, despite the First Amendment's protection of speech and assembly, local governments can still require, and sometimes refuse to grant, permits for parades and other gatherings. The United States Supreme Court assembled to explain why in Thomas v. Chicago Park District. The Chicago Park District, which operates Chicago's public parks, adopted an ordinance requiring a permit for any event involving more than 50 people or involving amplified sound. The ordinance required the district to process permit applications in the order received and to decide within 14 days. The district could extend that time for an additional 14 days. The ordinance listed 13 specific grounds for denying applications. If the district denied an application, it had to clearly explain why and, if feasible, propose measures to cure the defect. An unsuccessful applicant could appeal to the district's general superintendent and then to the Illinois state courts. Karen Thomas and the Windy City Hemp Development Board sought permits for rallies advocating marijuana legalization. The Park District granted some permits and denied others. Thomas and the board then sued the Park District in federal court. The district court granted summary judgment to the Park District, and the Seventh Circuit affirmed. The United States Supreme Court granted cert.